Hello, beautiful humans. Good afternoon. It is Thursday, May 29th, and right now in Maricopa County Superior Court in Phoenix, Arizona, is jury selection for the Vallow Daybell trial in the conspiracy to commit murder against Brandon Boudreaux. Now, from what I understand, there is no live stream of these proceedings right now. There are no cameras in the courtroom right now. And so I just want to go over what is happening there and give you some information about what other people are seeing in the courtroom. And the other thing that I want to go over is we started this morning to go over the information about Tammy Lechic. Well, it turns out that that was timely to go over that because apparently filed earlier today was Lori's response to Tammy Lechic being excluded by the state. And so I want to make sure that I cover that. Sorry, my microphone is in the wrong place. Just went live without checking. I want to look up those documents and see what we can find out about the reasons why Tammy Lechic would be excluded from the trial. But what I'm going to do right now is I'm going to go ahead and share with you what I know about what's happening in jury selection right now. I'm going to need to pull together a couple of things here. Thanks for your patience while I do this real quick. So I know earlier when we went live today, we were able to go over a lot of some of the information from the documents that came out in the FOIA request for the Charles Vallow trial. And that's where I found Tammy Lechic and found that she was a crime scene investigator for the Gilbert Police Department in 2019. And she filed a lot of the evidence that had to do with the Jeep, the Nissan Rogue, and some of the other things that were involved in that case. Lori again has asked for the evidence from the Jeep to also be excluded in this case. So I want to make sure that we take a look at all of that information and get everything on record. So good afternoon to all of you who are here. Welcome to the channel. I'm glad to have you here in the chat. If you have questions for me, please call attention to it with 3 question marks, 4 question marks, or some kind of an emoji so I can see it. So what I'm going to share with you is the X feed of Justin Lum, who was the original reporter on this case. He was the one who reported on Charles Vallow's shooting right from the beginning. He's been on there. And I just want to change up a little bit. So here is what's happening. Good to see you. Thanks for being here. Hey, Lamisa, always great to see you. Thank you so much for all of your support. You're very kind. So Justin Lum reported about 3:07, which would have been a little over 20 minutes ago, that he is in court for the screening. So I'm gathering that this started at 1 p.m. Arizona time. It's now, around 1:35 p.m. Arizona time. He says in court for screenings of jury questionnaires for Lori Daybell trial. Daybell is in her orange jumpsuit with her advisory counsel. Court striking and or passing jurors by reviewing questionnaires. In this process, when I was in court for this, for the previous trial, essentially they are looking at the responses from the electronic questionnaires that jurors were given. And the questions, we know they went over those in all of the pretrial hearings where it includes Lori's name, state versus Lori Daybell, as well as some information, preliminary information and questions about whether or not they'd been involved in a shooting trial before, or whether or not that I know in the Charles Vallow trial, they asked specifically if you have a problem viewing graphic images or crime scene photos and things like that. So we know some of the questions that are asked on those questionnaires. So both the defense and the state will have those questionnaires in front of them, and they'll go through them one by one. And the judge will call out the number of the juror. Now, this is a 4-digit number that's randomly assigned to each juror. The judge will call out that 4-digit number and say, I see a problem with question 12. And so I'm inclined to dismiss juror 4372 for cause, for bias, or whatever the case is. And then he'll say, does the state have any objection? And usually the state will say, I have no objection. Does the defense have any objection? The defense will say yes or no on that. So that's basically what they're doing right now, is they're going through those questionnaires one by one to see if they can find a pool of jurors to bring in person for voir dire tomorrow in person. So Justin Lum, again, reports he's there in the courtroom. He says the court has agreed to 10 jurors, this is 11 minutes ago, to remain in the pool so far. Dozens of questionnaires have been screened. Hardship issues vary from work to vacation to health. Many have heard about the Daybell case too. Interesting. One potential juror said in their questionnaire that they are a defense attorney and discussed the case on a local news channel. They were excused, obviously. I want to go and see what else is being said. One potential juror said that in their questionnaire that they are a defense. Okay, this is just a response to this. And then interestingly, Brandon Boudreaux just popped via conference on the monitor. He's sitting in his home with a white shirt and hat on. So a lot of the victims, the family members, are invited to go ahead and participate in the trial proceedings via Zoom. So even when there's not a camera in the courtroom, they're allowed to come in via Zoom to view the proceedings. And so I don't know, if it was me, I would probably turn my camera off. But apparently Brandon's cool with just being there and being viewed. So I'm just going to refresh Justin's feed here real quick. And let's just see a few more replies to this. Okay, so that's it as far as Justin Lum goes. And then let's go over to, I always like to check Nate Eaton also, because I believe he is in the courtroom as well. And he has a little more detailed information, I believe. So I'm looking for his original post here. Okay, so here we go. Back in Justin Beresky's Maricopa County courtroom, jury selection will begin this afternoon in Lori Vallow Daybell's final trial. There was a hearing earlier today, in case you missed the news, in front of another judge regarding Daybell's motion to have Beresky removed from the case. He gives a video link, but I'll just tell you what happened. They called a last-minute hearing at 9:30 Arizona time this morning to discuss Lori's recent motion that I went over on a live yesterday to have Judge Beresky removed from the case for bias. And we know she also made a verbal motion to that end. So this motion went before the magistrate, the chief magistrate for Maricopa County, and the hearing was only a couple of minutes long, and that motion was dismissed. So Judge Beresky will remain on the case, and there's literally no reason that he should be removed from the case. Lori did not provide any sort of evidence of bias whatsoever. So let me go back to Nate Eaton now. This is 36 minutes ago, just says, just walked in. Lori just walked in wearing an orange jail uniform. Her hair's curled and noticeably lighter. She smiled and said a few words to her advisory counsel. Beresky's now on the bench. Judge mentions a glitch with the juror identification system. Apparently, the numbering system has been changed. Parties are working to make sure they can accurately see the information. Now the issue's been resolved. Beresky begins reading down the list. First person has a job that would prevent them from serving. They're dismissed. Another juror excused because they have knowledge of the case. Another because they have non-refundable vacation planned. One juror advances. Another is excused for childcare issues. Another is excused because they have difficulty understanding English and they don't live in Maricopa County. Another has to work at Comic-Con during the trial, and that person is excused. We're on the 12th potential candidate so far. 3 have advanced. I appreciate this detailed reporting by Nate because these are the kind of notes I would be taking when I was in court. Other jurors have vacations planned, need to work, or have other knowledge of the case. Beresky's moving rapidly down the list. We're on juror 19 now. He reads their number, explains some information that was on their survey, and then prosecution and defense each weigh in on whether the person should stay or leave. So far, 6 have remained in the pool. So he's explaining the general process there, just like I did. Another potential juror would need the court to supply an Uber. Another has watched a TV show about the case. We're on number 30. 8 have advanced. These Maricopa County residents all received questionnaires last week asking about their knowledge of the case and whether they could serve. Tomorrow, the jury will be selected, 12 jurors, 4 alternates. They are aware that if they're picked, the trial will run June 2nd through 13th and possibly June 23rd. We're now on number 40. By my count, 11 possible jurors have advanced. One of the potential jurors is a defense attorney and appeared as a legal correspondent about the case on a local TV broadcast. That person is excused. The next juror has 8 children at home. Goodness, that person is excused for hardship. Another juror is dismissed as they have traumatic brain injury. On juror number 50, so far we have 12 who have advanced. We're on juror number 62. Several are being excused for different reasons, hardship, bias. One watched the last trial. 15 potential jurors have advanced. Brandon Boudreaux just popped up on the Zoom screen. We saw him momentarily, and then he turned his camera off. That answers that question for me. Judge reads off juror number 70. That person has prior knowledge of the defendant and child care issues. Brandon is allowed to watch and be in the courtroom for the entire trial as he is the victim. He's on the witness list and is expected to stand. Next juror is a detention officer who has transported Lori. He's also read about the case and he is dismissed. Good call. And then there's some comments from Nate's followers on X, so I'll just refresh here. And the last thing that he sent was, we are now on juror 81. We have nearly 20 people who have advanced in the pool. So if you missed this morning's live that I did, I went over some of the report that Tammy Lechic presented. And she is a crime scene investigator in Gilbert, Arizona. And she, the state had filed, I apologize. The state had filed a motion for certain of her testimony to be excluded, certain information from her report to be excluded, and Lori filed a response for that. And I've already asked Joe Schmo, who is my boots on the ground in there, to let me know if he noticed any new filings. And it looks like he did not get that message. So let me just try him again. I know he's in the courtroom, so I don't expect him to respond right away. If I could spell, those things would go faster. So I'm going to look back through the documents that Joe Schmo shared with me and see if I can find the original filing regarding Tammy. And so this was in, I did an episode with Joe Schmo where we went over a lot of different filings that came in all at the same time. Probably 4 or 5 different motions. So I'm going to look through those really quickly and see what I see. This is the minute entry. Court has received and reviewed defendant's motion to dismiss for abuse of discretion by Judge Beresky. I believe we went over that in the live. I'm going to take a look at all of these real quick. These are all minute entries that I'm looking at here from the various days of court in the last trial. Certificates of non-service for the witnesses that Lori was unable to subpoena. We went over all of those in the live, in one of my lives with Joe Schmo. I've been on with him several times where we've gone over lots of different documents. This one was May 9th. I think this is where We may have seen that. Okay, so I'm not finding that immediately, and I hate to spend so much time going over these things, but I really do want to find that filing. So if you guys will give me just a minute, I'm going to run over to the court website and see if I can find the filing that just came out today. So I'm looking on the docket calendar, and she is CR 2022. So I see I see the docket entries, but there's no access to the actual documents here. So I'm going to go back to another Maricopa County Superior Court and see what I can see. Meanwhile, Joe Schmo has responded. Yes, I just now downloaded them, 3 new filings. And I'm going to ask him to send because he might be faster when you can. He might be faster than me actually trying to find it. So in the meantime, good afternoon and welcome. I'm glad you're here. Thanks for being here. I always like to replay these little clips. This is my favorite one.
I've ruled on the motions as required by law.
Without any kind of a conclusion of law in them, just denied. Does that not show a bias and a prejudice against one single person?
All right. Are you done?
Are you not going to recuse yourself?
No, I'm denying your motion. Anything else?
It's just like the greatest hits. It's 29 minutes or 29 seconds of a bright spot in my day. Thanks for indulging me on that. So I'm over here looking at the court calendar. I see Lori's case. I see that they are in Judge Beresky's courtroom, which is 1104. And I'm looking for where I can find these court documents. Okay, so Joe Schmo says 5 minutes. I'm going to see if I can find it quicker than that. I used to have this all saved because I was so used to looking it up all the time, and I've gotten spoiled that Joe Schmo has been sending these to me. So let's see. ECR online. And so I got out of the habit of going there, and some of my bookmarks and stuff have gone away. Yeah, so I'm going to actually, what I'm going to do right now, since he's going to do it for me anyway, I'm just going to wait. I'm going to wait for that. But what I am going to do is I'm going to go over to Nate Eaton's reporting on the hearing this morning. And see if we can play some of that hearing that went on this morning. So let's take a look at that, because I think that is awesome. Yeah, I've heard that this is, I haven't watched the whole thing because I had a meeting like in between my morning live stream and this one. And I started to play it as I was traveling, and I didn't get a chance to finish it. So here's the court hearing, guys, from this morning, where Judge Green, who is the chief magistrate for Maricopa County, denied Lori Daybell's motion to have Judge Beresky removed from the trial. And so for those of you who are asking, what did I miss? Something new? Why are you back again? Well, jury selection is happening right now, and I know that that Nate Eaton and Justin Lum and Joe Schmo, they're all in the courtroom. And so I've been reading what's been going on with this jury selection since it's not being broadcast or televised. Right now, though, I am going to go and share with you the hearing from this morning, because I haven't played that yet on the channel. And so I'm going to go ahead and share. Oh, I'm already sharing this. So I'm going to go to one second, guys. Sometimes I make extra work for myself and I don't really need to. All right, so we're going to share this, and here we go. We're going to play this hearing. Okay, give me 1 second because I don't think the audio is working. Let me try this real quick. I'm going to remove it and then I'm going to add it back. I think it's because I have it on a separate window and it's okay. It's not going to let me do that. Okay, so let me just do, sorry guys. I'm trying to get the audio to share. So give me 1 second. I'm going to have to put this up in another window. And I'm afraid we might get commercials. I apologize if that's the case. And let me try one more time. Okay, let's try this.
00124201. This is State versus Lori Daybell. Appearances, please.
Attorney Kay on behalf of the state, and for the record, the victim is appearing virtually.
Thank you.
Lori Daybell for the defense. Pamela Hicks, advisory counsel.
Thank you. There was this got set very quickly. There was a media request that I became aware of in passing, literally on my way over here. I don't have a written request. I have not read all my email because I've been on the bench this morning. Do you want to make a record with regards to the media request from the state?
No, Your Honor.
Okay, from the defense?
No.
Okay. I don't see anyone here. I thought we would address it on the record, but I don't see anyone present from the media. Okay, I assume there's no objection if they come in. Ms. Kay?
No, Your Honor.
Ms. Daybell?
I always object to them, yes.
Oh, you object to them?
Always.
Okay. Is there anything you wanted to put on the record?
No.
All right. My thought is if they come in, we can address it. All right. The court's, this is the oral argument on Ms. Daybell's motion for change of judge for cause. The court's in receipt of and has reviewed motion to disqualify judge. This was filed on May 20th, and the state's response to defendant's motion to disqualify judge. Ms. Daybell, I've read your motion. In summary, the way I read it, you're asking for the court to remove Judge Beresky for cause under Rule 10.1. You cite several reasons, specifically that he's denied various motions. You mentioned facial expressions. You mentioned a belt and his not allowing you to remove it. You assert that he violated your speedy trial. There's a mention of religious persecution and an allegation of personal bias. So you're going to get, and then the state's response is that simply the defendant does not establish judicial bias, appearance of bias, or fundamental error. Of course, under Rule 10.1, the court is evaluating whether or not Judge Beresky can be fair and impartial, and whether he can conduct a fair and impartial trial in this matter. So I'm aware of the allegations. You'll have the opportunity to go first, then I'll allow the state and to address the court, and then you'll have the last word. Whenever you're ready, Ms. Daybell.
This is the pink salt recipe
Oh,
that took me from 198 to 140.
I'm so sorry, you guys. Give me a second and we'll skip this as soon as we can. Okay, here we go.
I did file this motion in this. I'm sorry, can you pull the microphone? Sorry. I did file this motion in this affidavit after several attempts to. I made an oral motion with Judge Beresky and asked him to recuse himself because of the bias and prejudice that I had seen during our last trial and throughout the whole entire time that he has been the judge over all of these cases. And he refused to do so. So I thought I needed to put it in writing and put all my points in that I felt like were causing him to be biased and prejudiced against me, and that obviously you've read it, so you've seen all the different things that I put. There was an actual comment during trial when I was cross-examining one of the witnesses where he said to me directly after an objection from this state that I was comparing myself to biblical prophets, which I absolutely was not doing. And I didn't even realize it until someone showed it to me on the FTR afterwards that he had even said that, because I was in the middle of questioning the witness. And so there's several times that he made comments directly to me. I tried to address this with him directly in our last hearing on May 14th, where I asked him why he had denied every single motion that I had ever filed in the last year and a half. And he said that my motions had no merit. I asked him if my prior defense team, that he denied all of their motions, that they had no merit as well. And then I asked him, my prior defense team before that, all the motions they filed were denied, and did they have no merit at all either? And I asked him again if he would recuse himself from this case so that I could get a judge that was impartial and fair and have a fair trial. That is my right, my 6th Amendment right and my 14th Amendment right to have a fair trial, an impartial trial, and not a judge who has some kind of bias against me.
All right, anything else? Thank you.
Judge, just the prior defense motions almost all exclusively dealt with motions to preclude the media. Judge Beresky applied the appropriate law in finding that the media had a right to be present and tried to limit it by saying things like they couldn't focus on the defendant's papers or things like that to mitigate any of the concerns by the defendant. All of the defendant's motions that she has filed have been without legal basis. They've been appropriately ruled on, and the state's motions that the state has won have been ruled on based upon, again, legal basis. So the fact, as the court is well aware, that the defendant has had all of the motions ruled against has no basis for bias if they're all been ruled on based upon the rules of law and the rules of evidence. So we see nothing that the defendant has provided here that would rise to a level to preclude or recuse Judge Beresky from this case.
Thank you. Ms. Daybell, you can have the last word.
Yes, also, along those lines, Your Honor, that's one thing that I asked Judge Beresky, is that he has denied all these motions with no finding of fact and no conclusion of law. I said, what is the finding of fact and conclusion of law? These are just denied, 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 denied. He's also denied several attempts for me to try to ask the state for discovery that he's just denied outright. And then as I keep filing more and more, as I find out what we don't have and I ask for it, I'm continually, even to last week, getting brand new discovery with brand new Bates numbers, stuff that they realized they never even had before that hadn't been turned over. And I've been asking Judge Beresky for these items for a year and a half. And I'm getting them 1 week before trial. We start picking our jury today. We're supposed to be doing our strikes today. And along those lines, I had this motion about the RAC belt that I had asked him about since we went through this whole trial, and there was times when the belt didn't fit around me, so it fell out of my clothing. We had to stop trial and I had to go fix it. And that is what MCSO recommended, that if that was too burdensome, that they would put an armed guard in the back. And because of the media that Judge Beresky has let into every single one of the hearings and the trial, that they already have an armed guard back there. So it wasn't going to cost the state any more money. It wasn't going to cost anything if he just had them remove the belt and went over the security that the MCSO actually recommended. Every single thing that I asked for has been denied. I feel like he does have a personal bias against me. And all I'm asking for, I went through a whole trial with him, even thinking he was biased against me before the trial started. I filed for a new motion because it came to our attention through the media. The media sent Judge Beresky a clip of one of the jurors saying that he found out about my prior convictions beforehand, before his deliberations. And this is the same exact juror who was brought in twice during trial by Judge Beresky, where he had to admonish him for, one, being on his phone, and two, talking to one of the other jurors about the case. And now he's saying, well, he went on another media thing and said that he took it back. He took back what he said. So I'm not going to give you a new trial, and nothing was done about it. He refused to call them in and have a hearing and put him on the stand under oath and ask him if he found out this information prior to deliberations. It was very confusing, and everything is just outright denied. I want to go to trial. I want to have a fair trial, as fair as possible. I don't feel like I can do that with Judge Beresky, and I would like to be appointed a new judge who wouldn't know anything about the case and be fair and as impartial as possible. Thank you.
Thank you. I've considered the written motion and the response, and certainly your comments today from both sides. Ms. Daybell, I find that the fact that you disagree with Judge Beresky's substantive legal rulings is not a valid basis under Rule 10.1 to grant your motion and give you a new judge. The standard in 10.1 is, has he demonstrated he can't be fair and impartial? And the fact that his rulings have not gone your way is not a valid basis to suggest that he can't be fair and impartial. Unless there's some other allegation of bias that's been demonstrated, I don't find on this record that it has been demonstrated. I certainly understand your frustration with the way that the rulings have come out, and it sounds like the way that they came out with prior counsel, but the things that you have cycled through at length in your motion to disqualify, I've considered all of them. Whether or not he should have ruled differently, for example, the example you gave with the juror, or with making findings of fact and conclusions of law in writing, some of the issues you have, if you have concerns about his substantive legal rulings, you can file a motion to reconsider, or you can take them up on appeal. You can file a special action. You have a number of legal remedies at your disposal where you can make those arguments, but they're not grounds under Rule 10.1 to get a new judge. So I am going to deny your motion. Again, as for your concern about his substantive legal rulings, you can address those concerns in a different way, but it would not be under a 10.1. And on this record, I don't find that he's demonstrated that he can't be fair and that he can't be impartial. I also wanted to address the comment that he made that you illustrated. That comment alone doesn't demonstrate that he can't be fair and impartial. I'm not exactly sure of the context where he made it, but it sounds like he let you ask a question with regards to religion, and that was his decision. But again, I don't think even that demonstrates that he can't be fair or impartial in this case. All right, so I'm denying the request to disqualify Judge Beresky under Rule 10.1. Is there anything else from the state?
No, Your Honor.
Anything else, Ms. Daybell?
Nope.
Thank you, we are adjourned.
It's like a wearable hug for your nervous system.
Sorry about that commercial there, guys. Nope. That was hilarious and wonderful. Okay, we're going to go now to, actually, I'm going to go back over to the live reporters that are in the courtroom for jury selection, just so that we can see or I guess read what's actually happening over there. I have to admit, I do have a little bit of FOMO of not actually being in the courtroom because I'm very particular about the notes that I take. I'm very particular about the things that I notice. And I was talking with Joe Schmo last night on a live I did with Kresha about some of the things that I observed in the courtroom. And I like to look at the jurors' facial expressions. I like to notice what's happening in the gallery. How are people reacting to certain things? I like to notice when the judge's staff are particularly animated. You know, sometimes things like that go on in the courtroom that the cameras don't pick up. And that is one reason why I have just a little bit of FOMO about not being there. But I literally just barely got my house back in order. I felt like yesterday was the first time that I could relax in my house again since the beginning of April, with all of that back and forth on the weekends and trying to get everybody, or get, you know, all my kids everything that they need. It was really a lot. So let me go ahead and share over here this the Twitter feed. Go to this one. Okay, so we're over here with Nate Eaton, and let me just adjust a little bit. Oops, did not mean to do that. Sorry, guys. FOMO is fear of missing out. Yeah, I do wish they had shown Lori's face as well. Okay, so where we left off last time, before we went over there for the, yeah, well, my cat's name is Karen. There's no media today or tomorrow because it's jury selection, but they are going to be televising the rest of the trial. I agree with you. Better than FAFO, which I think, what, fear of finding out? Or F around and find out. John Smith, I am not related to Heather Daybell by blood, but man, I have so much love and respect for her. I think she is a badass, and I want to be like her when I grow up. Okay, when we left off with Nate Eaton last time, over there at X, we saw the detention officer, we saw 81. Okay, juror 90, lots of different hardships in the last batch resulting in many dismissals. Employers in Arizona are not required by law to compensate employees while they are on jury duty. Jurors who have been selected receive $12 per day plus mileage, 67 cents a mile. Jurors can apply for additional compensation if they need financial assistance during jury service. And according to Judge Beresky, that amount can be up to $200 a day of compensation for their time serving. He says, we made it through 100 jurors and around 24 have advanced in the pool. One juror says they don't trust police. Lori wants them to remain in the pool and says they can be questioned during voir dire. Judge says they clearly wrote, I don't trust police. Judge overrules Lori's objection and the juror is dismissed. Way to go, Judge Beresky. Next juror says they will be in Idaho for family reunion. Good place to have a reunion. I hear it's much cooler this time of year. Yeah, sure. Than Arizona, definitely. During the last trial, 52 potential jurors advanced, and then 16 were picked from that group. It took about 90 minutes to get to the 52. We're about halfway to 52 and have been in court for around an hour. It seems far more jurors have heard about the Daybell versus the last trial. Well, gee, I wonder if that's because she had 2 public interviews on a local TV station in the same city where she's having a jury selection done. I mean, that definitely, I'm sure, impacted the jury pool. I just really, I don't know. Hey, so some people are noticing crowns in the chat, and this is something brand new that I just saw come up yesterday. I think YouTube is starting to try and create more engagement from live chatters, and I think they're giving people points for the amount of times that you comment or interact in the chat. And so I think it does like first, second, third place or something like that. I don't know anything about any of that stuff. I have nothing to do with it. So I'm going to dig into it a little more and find out why the heck they're doing that. Mrs. Smith, thank you so much for being a member for 11 months. I hope you get a crown. I don't know how to do that for you. I'm sorry. And I don't know if you spam the chat, I don't think that works. So just interesting. Super chats, stickers, and live chats. All right, well, okay. I mean, I don't know what to tell you over there. All right, so let's get back to Nate. We just got 2 potential jurors in a row who advanced a rare occurrence this afternoon, and then a third. And I'm going to just refresh to see if there's anything new. We are on number 137, and around 30 have advanced thus far. Majority of jurors are excused because they have knowledge of the case or Lori. Brandon Boudreaux's wife has joined the hearing via Zoom. All Zoom cameras are off. And I just want to mention here that on the first day of the last trial, Brandon Boudreaux was in the courtroom sitting next to me. Next to him was his wife. I was meeting her for the first time. I was actually meeting Brandon in person for the first time. I think we had only messaged maybe once or twice on Facebook prior to that. And many of you will remember the snafu where Lori did not want Brandon in the courtroom because she had put him on his witness list, on her witness list. And the judge said, what was I saying? My train of thought just bumped out. The judge said, "Oh, what relevance would this witness have to the case?" And Lori said, "Well, he was in communication with the victim at the time." And so the judge allowed Trina Kay, the prosecutor, to take Mr. Boudreaux out into a separate room to question him to find out if he did in fact have any relevance to the case at hand. And it came back that Trina Kay believed he did not have any relevance. So while Trina Kay was out talking with Brandon Boudreaux, I had a chance to speak a little bit with his wife. And she's a lovely woman. We talked just a little bit about things related to the case. She said, Lori thinks that he was in contact with Charles, but he wasn't in contact with Charles. Her belief was that possibly Melanie had blocked Charles's number on Brandon's phone. So Charles was trying to contact Brandon, but Brandon wasn't receiving those calls or text notifications because she believes Melanie had blocked Charles's number from Brandon's phone. And so she said, Brandon's wife said that he had not had any contact with Charles prior to his passing. And so I got to speak with her a little bit, and we talked a little bit about custody and how difficult that battle has been for them and how it must be. I want to keep that stuff private. But anyway, I thought she was lovely, and I hope that I get to speak with her again in the future. I did ask, if they were going to be around for the rest of the trial, and they said they were just going to be there for that one day. So I wonder how much she and Brandon will be in the courtroom for the trial. I'm looking forward to going back for the sentencing and the verdict, but that's all I'm going to be there for this time. It was definitely way more taxing than I thought it was going to be. So I'm going to go back now to the Twitter feed, to the X feed of Nate Eaton, and then we'll go back and look at Justin Lum as well and see if he has anything else interesting to say. I like all the different perspectives. So jury selection is not being televised or live streamed. A standby videographer from Fox 10 is here in case the judge decides to hear other motions. The video will be shared with media outlets should that happen. And that's what I was hoping was going to happen today, is that they were going to share or that they were going to address some of the outstanding motions, of which there are quite a few. But apparently that was not going to happen. So Justin Lum said about 30 seconds ago that we're about halfway through the list of questionnaires and there's a quick recess for court to get a break. And he says we may have around 30 jurors in the pool at this time. So that was it on that. Now, I'm going to go now to the filings regarding Tammy Lechic. And I don't know if it's Lechic or Lachick. I don't know how to pronounce her name, but to me, it looks like it might be Lechic. So that's what I'm going to say until I know differently. Sorry, a little bit of scratchy voice as I've been talking a lot today. That's what I think it is too. I think it's Lachick. But I am going to stop this one and I'm going to share this one. Okay, so this is this was filed on May 25th. It just came out today, and this is the defendant's response to the state's motion in limine to preclude inadmissible evidence relating to Tammy Lechic. Now, the state did a motion in limine to preclude inadmissible evidence relating to Tammy Lechic. That motion in limine was sealed, so we can't see the original. But we're going to learn a lot of information right here from this particular response. Just checking for any questions or anything I need to be aware of. So thank you guys. Oh, thank you so much, Ann Davis. That's really kind of you. Randy Watts was his name. I have since done another interview with him, along with my friend Jean Judson from Latter Daily Digest. That interview will probably go up sometime today. I hope to have it on my channel as well as Jean's channel. We talked with Randy about leaving the Mormon Church. And I plan to do lots more interviews with Randy and Jean. I love them both. I really appreciate them. Randy especially has an amazing amount of stories to share. So anyway, back to this response to the motion in limine. So the original motion was sealed. So we don't have the original motion from the state, but here is Lori's response. The defendant, am I sharing this? Okay, good. The defendant, Lori Daybell, respectfully requests that this court deny the state's motion in limine to preclude inadmissible evidence relating to Tammy Lechic. Excuse me. The information of incidents dated December 30th, 2024 through March 6th, 2025 of former forensic technician Tammy Lechic is information that is relevant to the witness's mental state, credibility, inaccuracy probabilities, and any probative value would be outweighed by unfair prejudice. The defendant will show support to claims in the below memorandum of points and authorities. Number one, the state's former expert Tammy Lechic's credibility is crucial in the case. Gilbert Police Department interoffice memo from Chief Michael Solberg, dated March 6, 2025. 1. Gilbert Police Department General Order 118.10, violation of any federal, state, or local administrative laws, rules, or regulations, refusing to provide truthful name. Check-in under Tammy Stoltz for her maiden name. So let me give you an idea of what's going on here. The original motion was sealed. However, Lori and I believe the state too are in possession of an incident, a report of an incident that occurred at a hotel, allegedly on March 6th, 2025. Actually, that's not when it occurred. I think that's when the report came in. So I'll try to find out what date this actually occurred. Apparently, Tammy Lechic is a former CSI from Gilbert, Arizona. Apparently, on this occasion, she checked into a hotel, and there were complaints being made about her overstaying her welcome there at the hotel. Police were called, and when they came into her room, they found that she was inebriated. There were empty alcohol bottles, and the room was in a state of disarray, et cetera, et cetera. Apparently, she refused to provide her real name, and there was an incident report, but eventually her son was called, and she was allowed to go home. There was later a disciplinary hearing. There was an investigation by Internal Affairs, and I guess they called her in to receive the results of that investigation, and she decided instead to resign, I think via email, if I remember correctly. And then if she hadn't resigned, she most likely would have been fired at that point. We'll get into a little bit more detail on that, but right now I just wanted to give you a little context so that so that you know what Lori's talking about in this motion. So this is a CSI investigator. She processed evidence relating to the Jeep that was used in the shooting of Brandon Boudreaux. She also processed Lori's vehicle, the Nissan Rogue, and Alex's vehicle, the Ford F-150. And so this is one of the crime scene investigators, and basically she apparently had some bad behavior that was calling into question her credibility as a witness. Lori is the one who's calling into question this credibility. Now, Lori has her investigator, Jeff White, fairly certain that he would be the one who gave her all of this information. So thank you, Zara, for pointing this out. Tammy collected evidence off the Jeep in 2019. The situation about her drinking was in December 2024. Thank you. This report wasn't filed until March. So I appreciate that, Zara. Thank you. And I hope I'm saying that right. You know, Eileen, thank you so much for this. As a member of the LDS Church, I have great sympathy and respect for Megan and other people that have left the church. There can be weird wards in Idaho and Utah. Luckily, I don't deal with that. And I will say, Eileen, I was in the same ward for virtually my entire married life. For about 22 years, I was in that ward. And I think it's fairly typical of an LDS ward. But if you ask my sister, who's a faithful member who lives in Provo, she always said to me, your ward sucks. Just because of the way that they treated me and the way that I was marginalized and all of that kind of stuff. So I leave a lot of room out there for the possibility that my ward possibly did just suck, but it was not a good experience. Did Cora Horde Lori have any reaction to Beresky being allowed to continue? Well, she's really not allowed outbursts in the courtroom, but when the presiding judge, Judge Green, asked if she had anything else, she goes, nope. And she popped her lips. I had to lick my lips so it'll happen. Nope, is what she said. So let's get back to this. Okay, facts and argument. This is Lori's response to the state. The state had a motion in limine to preclude inadmissible evidence relating to Tammy Lechic, and this is Lori's response. So we're talking about Gilbert Police Department filing this interoffice memo from Chief Michael Solberg, which I believe was the investigation into Tammy Lechic's actions in that hotel room incident. So she was, part of this was refusing to provide her truthful name. Check-in, she checked in under Tammy Stoltz, which is her maiden name. Number 2, failure to participate in or giving false or misleading statements or misrepresenting or omitting material information to a supervisor or other person in a position of authority in connection with any investigation or in the reporting of any department-related business. So essentially, sorry, I forgot I was not sharing my screen in case you want to see it. So apparently, during this investigation, it was found that Tammy Lechic failed to participate in, or she gave false or misleading statements or misrepresenting or omitting material information to a supervisor or other person in position of authority in connection with the investigation into her hotel room actions here. Also, conduct unbecoming a member. On paragraph 5, the recommendation of dismissal of FSS Tammy Lechic from employment with Gilbert Police Department, if she had not resigned, she would have been terminated. Ms. Tammy Lechic's former employer investigated Ms. Lechic's ethics and credibility in the above facts, providing false, misleading statements, misrepresenting and omitting material information, especially for the purpose of investigating impeachment by evidence of criminal conviction. In U.S. v. Hunt, detective knowingly made false report entries and with the intent to impede, obstruct, or influence of investigation, destruction, alteration, or falsification of federal investigation. Falsifying a police report is a federal document. A police report is a federal document. Falsifying it is against the law. Perjury in general. Fruit of the poisonous tree doctrine, a reason to doubt, the suppression of evidence and the inference of innocence. Ms. Tammy Lechic was at the time of the incident an officer and a member of the Gilbert Police Department. And then on Bates 101, 1015, Miss Lachic's alcohol content is, and I should say blood alcohol level is 0.157 after allegedly 8 hours of the last consumption of alcohol. And that is quite high. If you think that in most cases, the legal limit to be cleared to drive is 0.08, I believe. And this was 0.15. So almost twice the legal limit, even after 8 hours of the last consumption of alcohol. So that's quite a high blood alcohol level. On Bates number, I'm not going to say all the numbers, in Miss Lachic's interview, recollection of the event, she struggles with memory loss during the questioning or investigation. On the next Bates, Miss Lachick works for a government agency. She is in a position which requires her to testify in serious criminal matters. Miss Lachick states where she was mentally as far as having a mental breakdown, as on Bates 10-10-27, with alcohol and isolation. Ms. Lachick admits to alcohol use and isolation as her form of coping. With alcohol, mental state, and isolation, effects to memory loss, mental illness, and alcohol abuse. This exposes Ms. Lachick's competency to perform her duties on prior cases she was involved in, creating inaccuracies and false conclusions. On Bates 10-10-14, Ms. Lachick's son stated, she gets really, really, really drunk. It's been going on for years. Bates 10-10-15, 2 750 milliliter liquor bottles and about 10 shooters on. So I'm guessing that this is what they found in the hotel room was 2 liquor bottles and about 10 shooters or shot size bottles. On Bates 10-10-09, the condition of the room was observed and described by Officer Camarillo, quote, trash, several empty liquor bottles and vomit. This incident is a public record. On October 9th, 2019, Ms. Lachick photographed and processed DNA swabs and the GSR kits in Rexburg, Idaho's impound lot. As the above facts from an internal investigation into Ms. Tammy Lechic state, the expert's credibility is tainted. Ms. Lachick's long history of alcohol abuse and self-isolation in hotels raises the issue that Ms. Lachick may have been under the influence. So I just want to stop here to comment for a second because this is a decent legal argument from Lori calling into question the credibility. However, it's a stretch and not one that I would be willing to make to say that an incident that happened in 2024 would have affected this investigation she did in 2019. During the hotel incident, she was not on duty. And it's quite a stretch to say, and I think what Lori's implying here is that it could have been that she was under the influence while she was processing the crime scene. But in order for that to be a valid argument, I would think that Lori would need to bring in some proof that Ms. Lachick had been found to be inebriated while on duty, because this is, in her private time when she's not on duty, away from a case. It's not as though, she has a history of being inebriated on the job, which I think would be the real issue. I just want to look through. It's so hard for me to. Yeah, thank you for saying this, Zara. I've been researching this all afternoon, including the police reports, and I can't find anything that states she was not a good officer. So that's basically it right there. Oh man, 666 people in chat just for a second. Thanks for being here, guys. I really appreciate your support. Please do like, if you can, take a second, just hit the like real quick, because that means this live stream will get out to more people who are looking for this information about the trial. So Lori's asserting that her credibility is tainted. She says Ms. Lachick may have been under the influence. As Bates 10-10-09, she lacked hygiene care and has been coping with alcohol to cope with her mental state of mind, which is Department of Redundancy Department. And her hygiene isn't relevant to the case. I mean, I don't appreciate it when people have bad personal hygiene, but that doesn't mean, number one, that they're a bad person, number two, that they're bad at their job, or number three, that they should be, their credibility is tainted. The inaccuracy probabilities of cross-contamination of evidence. So I don't think that's what she meant to say, but we'll read the sentence as it is first. The inaccuracy probabilities of cross-contamination of evidence are high given the years of alcohol abuse which have affected Ms. Lachic's memory. This manifests fundamental unfairness and violation of due process. So again, there's no evidence that this has occurred prior to 2024. And if the son says she has a long history, well, let's interview the son and say, how long is long? Is it a couple of years? Is it a couple of months? Because that's relevant as well. If she didn't start this behavior until after 2019, it's completely irrelevant, right? And so I think what she's trying to say, the probability of inaccuracies and cross-contamination of evidence are high. But again, she wasn't drinking on the job. There's no evidence that she was drinking on the job. And I would even say that even if there was one instance or two instances of her drinking on the job, which probably would get her fired, I would think for the evidence to be called into question, she would have had to be found to be drinking on that specific occasion when she was testing that specific evidence. Just my opinion, again, not an attorney. Yes, Lori's a psychologist also. Yeah, this is true. So all the prosecutor has to do is talk about Tammy at the time of the investigation, not what she was doing 5 years later. So let's continue here. In State v. Bowles, Maricopa County reserved remanded. The testimony regarding the probability of a random match is inadmissible. Admission of improper testimony regarding DNA testing and the probability of a random match being tainted. Contamination, whether intentional or unintentional, could have occurred. Sample could have been contaminated by upset forensic expert, Rossum v. Patrick. So I don't think she's forming real coherent sentences here, which is on par for Lori, right? But it says, Ms. Lachick, forensic processing of the alleged crime scene is crucial for the breach of probable contamination, which addresses why the state is using Ms. Lachick, who was forced to resign due to the similar offense based on character and credibility, as the state is implying on the defendant. So because the state attacked Lori's credibility and character, Lori's saying, well, the state did the same thing to me. And now she's doing it to Tammy Lechic as well, which is, the way that Lori connects things is you have to view it from the lens that Lori is a perpetual victim. She's always being victimized by someone. And with that state of mind, you can look at something that's completely unrelated and relate it to you because of that victim mentality. So basically, Lori has a chip on her shoulder because the state has questioned Lori's character and credibility. And so now she's saying the state's doing the same thing to this witness. It's just wild. So, which addresses why the state is using Ms. Lachick, who was forced to resign due to the similar offense being based on character and credibility, as the state is implying on the defendant. I'm not saying that it's a coherent or a rational argument. I'm just saying I understand what Lori's saying here and why and how her mind is working in this case, but she's also kind of proving the state's case. Because remember, the whole point of this entire thing is that the state filed a motion in limine to preclude inadmissible evidence relating to Tammy Lechic. In other words, Lori wants to bring in this evidence to impeach Tammy Lechic. And the state wants to leave that evidence out. And so this is Lori's response to that. The state lacks the evidence, Lori says, the state lacks the evidence in truthful expert testimony. Ms. Tammy Lechic is an alleged witness. prior cases Ms. Lachick was involved with can be reopened based on the above. Well, that's your opinion. Questioning every case, fruit of the poisonous tree. That's not what that means. Exposing inaccuracy and collusion maybe? Prevent witness from tailoring statement. Not admissible is hearsay residual exception. Okay, I really would love to find out what is going on in the miscommunication between Lori and her paralegal. Because I don't think Lori is typing these things up, but I think maybe somebody is taking dictation as she's saying things and getting it inaccurate, or it's as Lori actually says, and they're on that prison phone system where there are things that cut in and out because there are words missing from all of these statements. Or do they not proofread? Or I don't know. It's just, Yeah, so Tammy processed the Jeep, the F-150, the Nissan Rogue, and some trash cans that were taken from, I believe, Charles's house. But they were all in police custody in the secured police impound. And there were other officers present as well. So let me just read this sentence with no emphasis or clarification of anything and see if you can help me figure this out. Quote, fruit of the poisonous tree doctrine, exposing inaccuracy and collision prevent witness from tailoring statement, not admissible is hearsay residual exception. I mean, I don't know if I need an English teacher or an attorney who's an English teacher or something. Anyway, I think I basically get it. In Mike v. Mraz, the prosecutor's duty to learn of any favorable evidence known to the others acting on the government's behalf in the case, including police. Again, sentence fragment. Both prosecutor and police cannot get around Brady, the state's breach of its constitutional duty to disclose evidence or impeachable evidence. Guys, I have neither the time nor the inclination to go back through this again and try to figure out what she should have said or would have said or whatever. But it sounds like what she's saying is that there was a case, Mike v. Mraz, where the prosecutor learned of favorable evidence known to the others acting on the government's behalf, including police. Both the prosecutor and the police can't ignore the Brady rules, and the state breached its constitutional duty to disclose evidence or impeachable evidence. In addition, violations of 170 AM Jury Trials 437, litigation of allegations of falsified or fabricated physical evidence in criminal investigations and prosecution, tampering with evidence criminally, intention of spoliation of evidence, obstruction of justice. Because character evidence is of slight probative value and may be prejudicial, the evidence bears directly on the charged crime. The court will fail to balance probative value evidence as compared to its prejudicial effect. Therefore, denial of due process regarding U.S. v. Wells. Deliberate fabrication of evidence by a state official is in violation of the Due Process Clause of the 14th Amendment. Finally, a coherent sentence. If evidence that officials continued their investigation of a person despite the fact that they knew or should have known that she was innocent, the investigator has an unlawful motivation to frame an innocent person. Destruction, alteration, or fabrication of records, documents, or tangible objects. Under Confrontation Clause, the defendant has the fundamental right to confront her accuser. Prosecution is knowingly soliciting false evidence or false testimony that will compromise the outcome. Government's failure to assist the defense by disclosing information helpful to conducting cross-examination is a constitutional violation which deprives the defendant of fair trial. The state will violate Rule 404B, unfair prejudice, by depriving the expert to prior acts into evidence, depriving Confrontation Clause and due process, but confusing the issues and misleading the jury by the facts above. Officers subject to impeachment, a witness's character for truthfulness or untruthfulness. Okay, let's just skip to the conclusion. Based on the above fact finding, as the defendant has established, arguably, the defendant requests that this court deny the state's motion in limine to preclude inadmissible evidence relating to Tammy Lechic. This court is obligated to grant the defendant's request. Fundamental error is reversed where such errors are found to be prejudicial to the defendant. It goes to the foundation of the case or takes from a defendant a right essential to her defense. So basically, oh goodness, okay, this is the body-worn camera footage from, this is actually what I was looking for. It's too bad that I didn't scroll down and just read this part. So this is the incident report of what actually happened on that day in the hotel room. Before I get to that though, I'm going to go back and look at the Twitter feed to see if we have any more info now that the break is most likely over. So this is Justin Lum's feed, which actually, okay, back in session, juror 157 excused. List keeps on moving as we're halfway through. We're into the 180s and expect to get through nearly 300 today. There should be a sizable pool of jurors once we wrap up. 12 jurors for alternates are needed. I'm going to go back over to Nate Eaton. He seemed to have a little bit more of a comprehensive reporting, which I appreciate. Okay, the judge says we're about halfway through the list. They took a short recess. Back on the record, juror 157. There are 295 in the pool that the judge will work through today. Several jurors in this group have health problems and are excused. Juror 185. A few have advanced, but the majority will be out of town, have work obligations, or have knowledge of the case. One juror didn't complete the questionnaire. Trina Kay says she has a problem bringing someone in who can't follow instructions. She asks that the juror be struck, and the judge and Lori agree. Just refreshing, and that's the last update there. So now let's go back to, I want to read the incident report with Tammy Lechic. Hey, Ruth, good to see you. Yeah, email me because we can meet up when you come in July. Ruth has a lovely business there in Phoenix. Ruth, if you want to put the name of your head spa, Ruth treated Kay Woodcock and Susan Vallow, who's Charles Vallow's sisters, to some treatments at her head spa there in Phoenix while they were there for the last trial. And they just raved about how wonderful it was. So I wanted to give Ruth a shout out. Zara, thank you for this. The poisonous tree theory is what say one apple on the tree is rotten and fake evidence. Therefore, you can request all the evidence gathered from the same person or the same area to be thrown out. Yeah. So Tammy Lechic is a crime scene investigator from Gilbert, Arizona. And right now we're discussing the motion in limine that the state filed to have certain evidence about her bad acts be left out of the trial. And this is Lori's response to that. Sorry that it always takes me a second to switch back and forth, guys. Okay, so this is the incident report from that day. I reviewed all relevant BWC footage, body-worn camera footage of the incident provided by Gila River Police Department. The first video was from Officer Camarillo's contact with Ms. Lechic. There was no sound to begin the video, but it was apparent he contacted hotel staff in the lobby. He then approached the door at room 324 and knocked several times. Ms. Lechic answered the door and the officer identified himself. Ms. Lechic confirmed she was Tammy. Officer Camarillo asked if he could enter the room and Ms. Lechic said no. Officer Camarillo placed his hand on the door and pushed it further open as Ms. Lechic stepped back into her room, still behind the door. She did give some resistance to the officer entering her room, but ultimately allowed him in. Ms. Lechic appeared disheveled and out of sorts. She appeared confused, when the officer told her she could not be in the room any longer. Ms. Lachick stated, "I checked out last night." Her speech pattern was slow and at times incoherent. She offered to show Officer Camarillo her receipt for the hotel reservation. The officer read the receipt and told Ms. Lachick her checkout date was 12:30 at 1400 hours. According to the timestamp on his body-worn camera, it was nearly 1500 hours at the time he was speaking to her. So she was an hour late for checkout. That's not that big of a deal, but maybe she was being loud, unruly, whatever. Officer Camarillo attempted to have Ms. Lachick answer some basic questions, such as, "Do you know what today is?" She did not and or could not answer his question, and she asked him to stop. Ms. Lachick asked the officer several times to leave or just let her go. The officer responded each time that he could not leave. Officer Camarillo observed the condition of the room, trash, several empty liquor bottles, and vomit. Sorry, guys. Just answering a text related to somebody investigating for me. He asked Ms. Lachick numerous times what was going on with her. Officer Camarillo asked her how much alcohol she had consumed, and she asked, "What is my checkout date?" The officer persisted, and Ms. Lachick did not answer his questions. He decided to request fire personnel for a medical contact for the female in room 324. She was not making any sense, and they were concerned about her condition. Gila River PD Officer Camarillo contacted the female in room 324, identified to him by hotel staff as Tammy Lechic. Ms. Lachick answered the door, and Officer Camarillo, oh, this is all stuff that we did already. Ms. Lachick was not cooperative with Officer Camarillo's questioning due to her state and the signs of intoxication. He made the decision to have fire personnel respond for an evaluation. Ms. Lachick was initially uncooperative with Gilbert Fire, but she did eventually allow them to conduct an evaluation. Ms. Lachick was cleared medically and was given an opportunity to call her son for a ride. When Ms. Lachick's son arrived at the hotel, Officer Camarillo spoke with him briefly. He told the officer his mother left the other day without telling anyone. He said it was a common occurrence for his mother, and she had done it for many years. He told the officer his mother was employed with the Gilbert Police Department as a crime scene technician. There was no mention in the report of any laws broken. In fact, Officer Camarillo told her son she did not break any laws. I think we're missing some info here, but this is as it was given to me. Something about let them go. She told her they had to stay. She asked Miss Lachick if she wanted to talk to her about any issues. I'm assuming this is the EMS personnel. As she was looking again around the corner to see if the male officer was still there, she replied, "I don't want to talk to you at all, especially with this guy," gestured in the direction of the male officer. The officer tried again to ensure things were okay with Miss Lachick at home. She said, "Yep, everything's good." Miss Lachick gathered her belongings and exited the room to meet her son in the parking lot. Outside in the parking lot, Officer Camarillo contacted Miss Lachick's son. He asked if something happened at the house with his mother. He said, no, she gets in like moods where she'll just disappear from everyone, not contact anyone, and just get like really, really drunk. Get hotel rooms. It's been going on for years. We try to offer help. We try to get her to, but she just doesn't want it. Okay. Officer Camarillo asked if Miss Lachick was employed. He said, yeah, she works for Gilbert PD, crime scene. We contacted her job. Obviously, you guys offer help, you know. Camarillo told the son he might reach out to Gilbert PD. He said that might be best. Officer Camarillo told the son, she hasn't broken any laws. The reason why we got called is because she already overstayed. When they went up there to find out why she didn't check out, Officer Camarillo never finishes his statement as Miss Lachick walked out of the hotel to meet with her son, and the contact concluded. Following the contact with Miss Lachick, Gila River PD contacted Gilbert PD pursuant to their policy of having contact with an employee of a law enforcement agency. Sergeant O'Hare authored a memorandum of his telephonic conversation with Officer Camarillo. Officer Camarillo told Sergeant O'Hare much of the same details written in his police report. He said Miss Lachick was refusing to leave her room and was disorderly toward hotel staff. He mentioned Ms. Lachick attempted to close the door on him like she did with the hotel manager prior to his arrival. Ms. Lachick refused to provide her name, and she was identified using her room reservation and police resources. Officer Camarillo said there were more than a couple of empty alcohol bottles in Ms. Lachick's room, to include 2 750 milliliter liquor bottles, and about 10 shooters. He said Ms. Lachick submitted to a portable breath test, which registered a blood alcohol content of 0.157. According to Ms. Lachick, it had been 8 hours since she had last consumed alcohol. Officer Camarillo concluded by stating Ms. Lachick was very close to getting arrested for trespassing, disorderly conduct, and failure to identify. A copy of the Gila River Police report, body-worn camera, and a copy of Sergeant O'Hare's memo are attached to this investigation. Now this kind of seems like it's cutting back and forth between reports here, because this seems like it goes back to the scene. Officer, her debit card, take it. I'm not trying to do anything illegal, just take my debit card. Ms. Lachick confirmed she did recall hotel staff going to her room to find out why she did not check out. I asked her if she tried to close her room door on the hotel employee trying to speak to her. She replied, no, I don't remember doing that at all. Like I said, the people that came, like housekeeping and also the guy in the blue shirt, they were super nice to me. So for those of you who are just joining us, this report is from an incident that happened in a hotel room with the crime scene investigator who processed the evidence on the Jeep Wrangler that was used in the shooting of Brandon Boudreaux. The state is trying to have this information precluded from the trial. Lori is trying to argue this information is relevant to the competency of the crime scene investigator. So yeah, the judge has to determine if this incident in 2024, this was in December of 2024, was relevant to the investigation in 2019. 2019 is when she actually collected the evidence. This incident happened in 2024. Now, the Sun did say several years. Well, that could mean 3 years. That would have been 21, 22, 23, 22, 23, 24. It could have been way afterwards. So going on with this, I asked Ms. Lachick if she tried to close the room door on the first officer who showed up to her room. She said, not that I recall. It might have been no, and then he did push his way in. I was like, oh, okay, I asked Ms. Lachick if she recalled refusing to provide the officer her identification. She stated, I don't remember doing that. When the female officer asked me for it, here you go. I don't remember doing that, so I don't recall. I asked Ms. Lachick if she recalled asking the male officer to leave several times. She said, I don't actually recall that either. Maybe I did because, like I said, was I rude to him? Yes. Looking back, I wish obviously I would have treated him with respect. So maybe this is an interview that is happening after the incident, after she is now sober. But I felt like I was being judged, and I felt I felt little and not human. Maybe that was just, I'm not saying that's right, but that's what happened. I don't know. I asked Ms. Lachick to clarify her reasoning for her lack of cooperation with the male officer as opposed to the female officer. She said when he first came in, he had his hands tucked in his vest or whatever and was just walking around and was like, looks like you're having a party here. It made me feel like shit. I was breaking down, mentally breaking down. Here he is judging me. I was like, F. I felt like I needed help more than judgment. Oh man, I'm really feeling for this lady. Help me get out of here, mentally help me and not judge me. That's how I felt. So guys, I just want to say, man, I'm really feeling for this lady, okay? Because law enforcement officers deal with a lot. And, if you've already had past trauma of any kind, dealing with families, domestic violence situations, processing crime scene information, that can all be really mentally taxing. I dated a firefighter for a few months, and he had a really hard time processing what he was seeing and going through. This was in the spring of 2020. And, did a similar thing, not that he would get wasted, but that he would check out for a few days and I wouldn't hear from him for 2 or 3 days at a time. So I know there are a lot of law enforcement people who deal with mental health issues. And my response to somebody like this, who's coping in this way, would not be to shame them for what they're doing, but to ask them, why is it that you're hurting so much? What is it that you're numbing? You know, what pain are you numbing? What are you trying to run from? And she is asking for help here, really. I mean, she's saying, I felt like what I needed was help, not judgment. Man, that just really, that gets me, you guys, because it's hard to reach out for help. It's hard to admit that you have a problem or that you may be numbing more than you want to or whatever. So my heart goes out to this lady. I hope that she has gotten help since then. And I hope that she is not hurting anymore. So yeah, medical field and law enforcement, all seeing horrible things and, you know, dealing with it the best they can. And admittedly, this probably isn't the healthiest way to deal with it. But let's say this, at least she wasn't getting drunk in a bar and then driving home and endangering the lives of everyone on the road. You know, at least she wasn't getting drunk at home and mistreating her children. You know, there are lots of worse things than checking into a hotel room to go on a drinking binge. Is it healthy? No. Is it the best way to deal with it? Probably not, you know, but man, at least, you know, she's trying hard to you know, to isolate herself so she doesn't hurt other people, I think. I don't know, in my opinion. I feel for this lady, and I hope that we can all have some compassion for her too. That's all. So going back, I'm just like all in my feels today, you guys. I've been very emotional today, honestly. In relation to why she responded positively to the female officer and displayed a reluctance to speak while the male officer was in the room, Ms. Lachick stated, I didn't like the way I was being treated. I felt like I was being judged. When the female officer came in, she treated me like a human, like, okay, I can have a conversation, you know, that's all it was. I asked Ms. Lachick if she ever identified herself as a Town of Gilbert employee during her contact with the police. She said, no, not that I recall anyway. I asked her if she knew how the officer obtained her employment information. She said, I do. So they asked my son, what does your mom do for a living? And then my son mentioned where I work. I asked Ms. Lachick if the officer ever told her she could have been arrested for anything specific. She said, he just said I could go to jail. I'm like, for what? It was at the very beginning. He was like, either you get checked out by fire or you're going to jail. I'm like, holy cow, what did I do? I'm not running down the halls acting like a crazy. I stayed in my room. I'm trying to like pay if I need to pay. I was just so damn confused. And maybe she was thinking like about extending her reservation or paying for an extra day. I asked Ms. Lachick if she received any paperwork from the officer or if she was verbally told she was trespassed from the hotel. She stated, no, not that I recall. I didn't get anything. The only paperwork that I got was from you guys on the 2nd NOI. No, that was it. I didn't even know that until you said something. Considering Ms. Lachick works for a government agency, she's in a position which requires her to testify in serious criminal matters, and her contact with the police was recorded and is public record. I asked her if she felt her conduct that day constituted an allegation of conduct unbecoming. Joe Schmo checking in with the details. He says, I was telling him that I'd love to have the body camera footage from this interaction. And he said, one problem, it's an Indian reservation, so it's not subject to state or U.S. Supreme Court FOIA rulings and laws. But they have a website to request, so we'll see how it goes. I love Joe Schmo. He is a great investigator. I've had him on my channel several times, and I like collaborating with him. He's a good guy. She replied, given the circumstances of where I was mentally, as far as having a mental breakdown, I feel like not that I could justify it, but if somebody could, and then it cuts off, and I think the pages are out of order. Yeah, I think there's pages missing, and we're going to get to this. There are pages missing from this. So this is the conclusion. a summary of what happened, basically. So we've been all through it, so I'm not going to go over the summary. But it says, when Ms. Lachick was questioned in her administrative interview about having overstayed her hotel reservation, she provided bank statements which showed she was charged for and paid for 5 total nights at the hotel, to include the day after she was contacted by Gila River PD. So she turns out she was actually right. She had paid for the next day. Ms. Lachick said, due to her intoxication, confusion, and disbelief of why she was contacted by the police, she did not have the wherewithal to provide her proof of payment at the time of contact. So really, this never should have happened in the first place. There was no report of a disturbance caused by Ms. Lachick, only that she closed the door on hotel staff and the officer, which she denied in her interview. So I'm curious about why hotel staff even came up there in the first place. If there was no disturbance, there was no report of a disturbance, they had no reason to go up to her room. She had another day on her reservation. I just don't get it. Ms. Lachick did not recall ever being told she could have been arrested, and she did not recall being told she was trespassed from the hotel. She was not given documentation by GRPD. Ms. Lachick has since contacted GPT Wellness and been provided resources to better handle the stressors in her life and at work. I'm glad to hear that. So this is the interoffice memo, and as we heard before already, that had she not resigned, she would have been fired because of this instance. So this, we read this already, the defendant's objection to request, oh, sorry, no, we did not. So what we read up to this point was the motion, the original motion in limine filed by the state was sealed, so we don't have that. But then we have the defendant's response to the state's motion in limine to preclude inadmissible evidence relating to Tammy Lechic. Just going to check the chat here real quick to see. Oh, nice, Sarah. I'm glad that you're dealing directly with Joe as well. Yes, she is directly in the Daybell Brandon case. This is the crime scene investigator that processed the Jeep that was involved in the alleged shooting of Brandon Boudreaux. She is the crime scene technician that processed all of the evidence related to the Jeep and all of the evidence related to Lori's Nissan Rogue and Alex's Ford F-150. This is directly related to this case, for which they're doing jury selection right now at this moment. So I would not be going through all of this if it wasn't relevant to this case. Yeah, we just showed that video. Yeah, and I agree. I really hope she's getting the help that she needs. So now I'm going to go and review one more document from Lori. This is the defendant's objection and request to unseal the state's motion in limine to preclude inadmissible evidence relating to Tammy Lechic. And this was filed on the 25th, but again, just came out today, became available today, I should say. The defendant, Lori Daybell, respectfully requests that this court deny the state's request to seal the state's motion in limine to preclude inadmissible evidence related to Tammy Lechic. The information of incidents dated December 30th, 2024 through March 6, 2025 of former forensic technician Tammy Lechic is information that is relevant to the witness's mental state, credibility, inaccuracy, probabilities, and any probative value would be outweighed by unfair prejudice. So she's just repeating what she said in her response to the state's motion. Now she's objecting that the state wants to seal this motion in limine. The defendant requests that the record be unsealed. The defendant will show support to claims in below memorandum. And before we actually go through this, I think this is just, it looks to me on the surface to be a regurgitation of what we already read in the prior motion. So I'm not going to go through this entire thing. Joe Schmo just sent these to me, so this is the first time that I'm seeing them. So let's just skip to the conclusion. Based on the above fact finding, as the defendant has established, the defendant requests that this court grant the defendant's objections and request to unseal the state's motion in limine to preclude inadmissible evidence relating to Tammy Lechic. This court is obligated to grant the defense requests. Well, they're not, but in your opinion, maybe. Fundamental error is reversed where such errors are found to be prejudicial to the defendant. Fundamental error is an error that goes to the foundation of the case or takes from a defendant's right essential to her defense. So again, she's just reattaching everything that she reattached or that she attached to that other motion that we already went through. So thank goodness it's not necessary for us to go through that whole thing again. Now, what I am going to do is go back to the Twitter feeds and see if I can see what else is going on. In the courtroom right now is Nate Eaton and Justin Lum and Joe Schmo. Oh, thank you for this. AA from AA, who has helped me with investigations in the past. FYI from your friendly hotel manager. That's right. Staff went to the room because of the mistake. They thought she was supposed to leave. Should have double checked that before getting law enforcement involved. Thank you. That's what I think as well. Kind of a big error when it results in an investigation that gets an officer fired. You know, that's kind of a big deal. 1 second, guys. Sorry, guys, coordinating kid stuff. So one last check on over here to the Twitter feeds. Yeah, I'm doing great. Thank you. I was a little I was a little emotional this morning. I have had a little bit of anxiety about this trial starting. You know, here we go, round 3, at it again. I feel in my body. I know what happens in my body when this process begins. I feel the anticipation of those feelings, and it's like, okay, like I'm bracing for impact. So I'm doing really good self-care, and I am taking care of myself. And the best part of that is being here at home with my support people, my kids, my dogs, my partner, my comfort things here in my own home rather than being in Arizona. So even though I am a little sad about missing out on some things, this is a place I need to be. This is where it's best for my mental health. And I don't think my reporting is going to suffer that much. Okay. It looks like there's some funny stuff coming up here from Nate Eaton on his X feed. So the last we left off, I believed the juror didn't complete the questionnaire. Then we had about 95 left to go. Around 30 to 40 have advanced. As the judge reads the numbers, Lori and her advisory counsel look at the laptop screen. Lori has a yellow notepad and is writing the numbers using a short pencil. She's got that prison pencil, guys. Her handcuffs and leg shackles remain on. We are on juror 230. Vast majority are getting dismissed due to trial knowledge, vacation plans, health challenges, or other issues. Judge says the next juror form, quote, feels like she's yelling at us in all caps. Trina K motions to dismiss for cause. Lori agrees. We are on juror number 250. A few have advanced in the last group. Most have not. Around 45 more to go. One juror wrote on their questionnaire that their grandfather was a DPS and, quote, if he says you did it, you did it. That juror is dismissed. I think that's pretty funny. Sorry. I just, yeah, of course you would want to dismiss that person. Okay, I'm going to go back to Justin Lum to see if he has, oops, if I could type properly, to see if he has anything additional. Wondering how many jurors just said they heard about the case to be excused. Not much elaboration on how much they know. That's an interesting problem because it's real easy to just say, yeah, I've heard about that case. And then of course they're going to dismiss you. We are nearing 240. Another juror passes through. Last trial, we reached a pool of 52 jurors going into in-person selection. Should meet the same amount or more. And I agree. I hope that they have a few more than we did last time, and I hope that the in-person voir dire goes a little better than it did last time. No, there are no jurors in person, AZ Mermaid. These are just the electronic questionnaires that went out that the jurors answered, and they're going through the questionnaires themselves. So in other words, they have a sheet with the questionnaire with the juror's number on it and the answer to all of their questions, and they go through each one of those questionnaires to see if there's any problematic answers, red flags, if you will. So the people who survive this round of basically review, they're going to come in person tomorrow for voir dire in person. Yeah, I hope there's no, well, I hope it's not publicly available. I mean, FOIA request could become publicly available, but I hope that, I don't know, if it's an internal police investigation and no civilians were involved, I don't know if they would release that or not. I don't know what the rules are actually. So let me go over, somebody asked what Hidden True Crime was saying on X. And to be honest with you, I don't think Lauren is super active on her Twitter feed, her X feed. So the last thing that I see from there was posted back on May 13th. So she doesn't have anything there today. And I'm going to go all the way back because I think we're almost done, guys. I think we're wrapping up here. And the only other thing that we could do while we're waiting for jury selection to finish for the day is I could go back and finish reading the report that Tammy Lechic submitted in the FOIA documents. It was part of the FOIA documents. And the report that she submitted and the evidence that was in there. See, I was thinking prior to receiving this information, I was thinking that the reason that Lori wanted, or I was thinking that it was Lori that wanted the evidence to be precluded, but it wasn't. It was the state. I was thinking there was something in that report that Lori didn't want admitted into the trial. And so I was reading through all of that to see what I could see if there was anything I thought Lori would not want admitted. There is evidence of other crimes in that report. And we do not yet have a ruling about whether or not her prior convictions can be mentioned, because where it stands right now is that Trina K originally filed a motion to bring in her prior convictions. Then she asked for that motion to be stricken from the record, and she resubmitted a motion that only included count 7 of her Idaho conviction, which was fraud by deception. So that's an interesting play on Trina K's part. And I have a little bit of speculation, and maybe Zara, maybe you can weigh in on this. I don't know if you're a prosecutor or where you are in the legal world, but you know, I think that probably the most damning evidence that the jury could receive would be if Lori decides to take the stand. I think that would be probably the worst thing that she could do, because people are going to, the jury's going to see how she behaves, how she reacts to being questioned. They're going to see her get defensive. They're going to see her use manipulation tactics. She's going to obfuscate. They're going to see all of those tactics. And so if she testified, I think that would be the worst thing for her. So I wonder if Trina K withdrew her original motion to have all of her priors brought in because she's trying to entice Lori. Hey, it's okay. We won't talk about the murders. We're only going to talk about the fraud. You know, fraud goes to her character. And I think Jermaine is right. If they bring in that fraud by deception charge, it'll show the jury that she has been convicted of fraud in the past. She could be lying. But maybe it is a little bit of a tactic on Trina K's part to entice Lori to testify. I don't know. I am not nervous about Brandon being cross-examined by Lori just because I think Brandon will hold his own. I think we're going to see some more Nancy Joe moments if that happens. If you haven't seen the video where I unpack Tammy, sorry, not Tammy, Nancy Joe's testimony in the previous trial, please go watch it. Nancy Joe is a rock star, and I absolutely love the way she handled Lori. And it was a perfect example of how to handle somebody who's a manipulator. Textbook. I think she is going to ramp it up, definitely. Yes, and what we want is for Lori to testify, so that's why the ruling was removed. I think so, and that's, in my opinion, I think that this is a little bit of a you know, fishing expedition on the part of Trina K to say, you know, hey, we won't talk about the really bad stuff. We'll just talk about the fraud, and you know, they will never know that you've been convicted of unaliving your own children. And that way it makes it safer for Lori to take the stand and testify. And that's what I hope happens, because I think that will be the worst thing for her case, as I just said. Was it you who said Lori thinks fair means the judge should rule her way at least half of the time, and that's why she's so mad and feels like he's biased? I did say something to that effect. I believe that fair means different things to different people. And I taught my kids growing up that there is no such thing as fair. Because if fair means everybody gets the same or everybody gets equal, then that doesn't really exist in life. And the example that I would use with my kids, because they would say, hey, that's not fair. He got to drive when he was 16 and I had to wait till I was 18. The example I would use with them when they were younger is I would say, okay, on Easter, the girls get new dresses and the boys get new suits. If it's fair, then the boys also get new dresses and the girls also get new suits. Is that fair? And I used to try to teach them that fair means that everybody gets what they need. At least in my household, that's how I ran things. But I know that the word fair means different things to different people. And I think it was my grandfather, not on Lori's side, who said, fair's where you go to see the pigs. So anyway, I do think that Lori believes she's been treated unfairly because her objections got overruled, her motions got denied, and the state got, you know, their stuff admitted. Thanks so much for, I don't know, noticing my earrings. Guys, sometimes when I'm feeling especially anxious or sad or depressed, I get up, I get fully dressed in a nice outfit, I do my hair and my makeup, and then at least if I don't feel well, at least I look good. And that sort of boosts my mood a little bit. So, so thank you so much for the kind words, Carolyn, and so many of you are saying kind things. I really appreciate you guys. Equity and equality are not the same. Thank you, Eliza. That is true in my opinion as well. Yeah, there are missing papers in the report, and that reminds me, actually, there was one more motion, I think, by Lori that I need to go and open. Page 5 and 6 are missing. Yeah. Hey, please, Andrielle, please send it to me when you're done writing it. I would love to see it. You can email me at askmegan@gmail.com. Well, what do you know? Her motions and objections have to be based and established in law. How is this so shocking to Lori? Well, it's shocking to Lori because Lori believes that she should get whatever she wants. And throughout her life, she pretty much has. And she's used charm and manipulation to get it. And that's not working in a court of law because she can't use her same tactics. And I think that makes her brain short circuit. She doesn't understand why that's the case. So let me go back to this email really quick that Joe Schmo sent me, because I thought I remembered reading something. Oh, yeah. Here's what it is. Thank you for jogging my brain a little bit, you guys. No, that's not what I meant to do. I meant to do this. So this is the state's notice of missing pages of notes. The state of Arizona, through undersigned counsel, hereby notifies the defendant that there are 2 pages of notes from Tammy Lechic that cannot be located and have not been disclosed. On December 12, 2023, the state disclosed the supplements, the list of impounded items, and notes created by Tammy Lechic. This is in relation to her report. Bates 2059 and 2063 are 5 of the 7 pages of notes prepared by Gilbert Police Department criminalist Tammy Lechic on November 18, 2019. On May 15, 2025, the state realized that it was missing pages 6 and 7 of Lechic's notes. The state reached out to Gilbert Police Department, Phoenix Police Department, and Mesa Police Department to obtain the additional 2 pages. On May 22, 2025, the state was advised that Gilbert Police Department searched all their databases, including their OneDrive, home drive, and an old iPad used by Lechic. The Gilbert Police Department has confirmed they no longer have copies of Lechic's notes. Arizona Rules of Criminal Procedure, Rule 15.4, provides that, quote, handwritten notes are not a statement if they were substantially incorporated into a document or report no later than 30 calendar days of their creation, or were preserved electronically, mechanically, or by verbatim dictation. Lechic's report, Bates 1844 to 1945, and the notes, Bates 2059 to 2063, involves the collection of evidence from the Jeep on November 18, 2019. So please, nobody tell me that that law enforcement was not investigating this crime in November, because they already had the Jeep and they were already processing it at this time. This was before a lot of the stuff happened. The report was written on December 2nd, 2019, which is within 30 days of the search of the Jeep and the creation of the notes. The state is simply providing notice to the defendant of the 2 missing pages of notes. So that's important, that there are notes missing from that actual report. And that's when I was going to go back and read the rest of the report. Just checking chat, guys. So Intervisions asks, is there a connection between Tammy Lechic's behavior on 12/20/24 and performing her duties as a Gilbert Police Department crime scene technician? No, there's not. And this was back in 2019 that she did the evidence collection, so it really should not be relevant, in my opinion. I don't know if this was ruled on. I don't think it was. As far as the notes that I have, that is still a motion that's outstanding. I don't know if it's been ruled on or not. I don't know if we have a final ruling. That's what I was hoping, that before all of this jury selection happened today, that they would have brought up the motions that are outstanding. But I'm guessing that will come up tomorrow when the jury is there in person, and I'm hopeful that the judge will address all the outstanding motions prior to the jury being brought in. So let me just check again on Twitter to see if we're any farther along in that process. I really don't want to let go of this live until we have the number of people who are going to be coming in tomorrow, because I think that's important. We only have, so they're on juror 290 right now of 295. So it should be fairly soon, like within the next couple of minutes, that we find out whether or not, or how many people are going to be moving on tomorrow. You know, Carolina, this is a good point. I do think that the judge is going to be more firm with her going forward. She's had a whole trial now to make mistakes and do things the wrong way, and have the judge sort of help her along and be overly accommodating. And I think now that she's asked for the judge to be recused twice and been denied twice, I think the judge will be a little harder on her now. However, I think he is still going to be careful to make sure she gets a fair trial, because the last thing that we want is for her to have reason for an appeal to be granted. Yeah, I think that's the reason why. Okay, let me go back now to, if I can find it, the Tammy Lechic report. That's not it. As usual, I have too many tabs open. Thanks for your patience, guys. There's probably some stuff that I should close down here. That's not it. Ooh, where did it go? Did I close it? Oh no. Oh, nope. That's not it either. Shoot. Did I bet I pulled it out into a separate, yeah, I did. I pulled it out into a separate window. Okay, so let me share this with you guys. Hey, thanks for becoming a member, Ray Jones. Good to have you here. No, I don't think Judge Beresky is capable of being triggered, honestly. I think that he does such a great job of dealing with Lori. All right, so I'm going to share this window where I have, okay, so this is picking up where I left off this morning. I had to leave because I had a meeting actually a little afternoon today is when I stopped that live stream to go to a meeting and then come back for this. And so this is part of the report that was submitted by Tammy Lechic, and it included some of the information from other investigators as well. So we've been going through that. Now we talked about the contact Detective McDermott made with Colby. Colby was in possession of the Nissan Rogue at the time the police seized it for evidence processing. And then Alex's Ford F-150 was processed for evidence, and a confirmed blood stain was found on the front passenger seat in the vehicle. Melanie Pulowski, this is Melanie with an I, was interviewed again by the FBI in Idaho. This is Lori's niece, Melanie, formerly Boudreaux, formerly married to Brandon Boudreaux. Melanie was dishonest about facts redacted. Melanie did not provide any additional leads or investigative information. Melanie was not challenged on her lies because Ian was present. Ian was her new husband. He was divorced in August of 2019. Melanie and Ian met in November of 2019 and were married 2 weeks later. On their honeymoon night, Melanie shared with Ian some of the things that she believes about the Church of the Firstborn. Ian was concerned enough about this that he reached out to his ex-wife to say that he was concerned about the safety of their kids. And I believe they together went to police to talk about it. And later the FBI asked Ian to wear a wire to record conversations between Melanie and Lori and Chad. Now, nothing confessional or damning came out of their recordings, but we sure did learn a lot more about their belief system. And so at the time that Melanie was interviewed regarding Brandon's shooting, well, I don't know if it was regarding Brandon's shooting or the whole case in general, but this was December of 2019. At this time, I believe Ian was still wearing a wire for those meetings, cooperating with law enforcement, and that's why Melanie was not challenged about her lies. Then December 27th, 2019, during a conference call, it was learned that the media release brought forth a lot of investigative information. This was just after the media release to find the missing kids, Tylee and JJ. Both true and untrue information. Lori and Chad were contacted by prosecutors from Rexburg, but maintained that JJ and Tylee were safe and refused to cooperate with law enforcement. Redacted revealed Alex and Redacted traveled together to the area of Yellowstone National Park on September 8th, 2019. We know that it was Alex, Lori, JJ, and Tylee. But additional Redacted was still in progress. Assistance was requested for the Idaho agencies to obtain buccal swabs from family members who would have had access to Lori's Nissan and or Alex's Ford, so it could be compared to the samples collected in Gilbert. 12/28/2019, I interviewed Neil Mestis, who was the dog trainer for JJ's service animal. Neil said Lori emailed him on 7/22 of 2019. So this is July 22nd. This is just about 11 days after Charles was killed. Lori wanted to return the dog as a result of Charles's death. That makes no sense. JJ needed that dog. Lori did not provide specifics for how Charles died. Neil agreed to pick up the dog on August 15th of 2019 and recalled seeing both Tylee and JJ in good health. They didn't leave Arizona until, I believe, August 30th. On the 29th of December 2019, additional warrant results returned then were forwarded to the FBI for analysis. A lab request was completed and biological evidence from the Nissan and Ford were forwarded to the Mesa Crime Lab for analysis. New Year's Eve 2019, Detective McDermott and I contacted and interviewed Lori's friend, Julie Clement. Julie identified herself as a spiritual healer for Lori, Chad, and Zulema. Julie said she last talked with Lori and Chad via phone yesterday. Julie was asked to provide their updated phone numbers, but she refused. Julie denied knowledge about JJ and Tylee's location or welfare. I provided Julie with my business card and encouraged her to call me if she remembered anything helpful. Analysis of Zulema and Alex's redacted was completed to be served on Alex's truck. Lori and Chad were still located in Hawaii, and the welfare location for Tylee and JJ remained unknown. So that's the end of the supplement. These are additional notes, but they go back. They're going backwards to to December 21st, 23rd, and we've already been through that. So sometimes these are a little bit redundant. I'm just scanning here to see if there's anything related to this case. Yeah, at the conclusion of this summary, additional supplements will follow with emphasis on the crime committed in Gilbert against Brandon Boudreaux. So let's go down to that. Okay. We've already read that. Melanie's second interview. Oh, Melanie, this is Melanie Gibb. We've already read that. Okay, and then we get to supplement information that is from a different person. So my point in doing that was to go through what was submitted by Tammy Lechic, and we did that. I just thought that there was evidence that Lori wanted left out that was submitted by Tammy Lechic, but it was not about the evidence, apparently. It was about Tammy's competency as a crime scene investigator. But in my opinion, after reading all of those notes and what happened in the incident, I don't think that that had anything to do with it. And I agree with this, Intervisions. I talk about this a lot in my video on Barry Cox, that Melanie's had a very traumatic childhood from which she has never recovered. She never got the mental health counseling she needed. Not an excuse, just an observation. Okay, I'm going to go back and check Twitter. I think we must be close to being done. Have a jury for tomorrow, or have a pool for tomorrow. Oops, that is the wrong tab. It's just kind of comical. If you could only see, I literally have 4 different Google Chrome windows open, and they each have about 10 tabs open as well. So going back to Nate Eaton. Okay, so we have some final information now for this jury selection, electronic jury selection today. Thanks for being here with me, guys, and going through all of this. I know it's been a long haul. We're about 2 hours in here, but here we go at the end of the day. Makes me want to start singing Les Mis songs. Nate Eaton report. The judge continues to read numbers past 295 and finishes at number 302. There were some blanks throughout the list. Beresky believes we have a pool of 67 potential jurors. Judge said the e-questionnaire process speeds things up as he just screened through 295 potential jurors. More walk-ins could show up tomorrow. The final number we have is 66 in the pool, and they will show up tomorrow for in-person questioning. So there we go. The magic number is 66. So tomorrow morning at 10 o'clock Arizona time, court will be in session. I'm hopeful that they will review the outstanding motions. I'm hopeful the judge will rule on those outstanding motions. And then they will go through the in-person voir dire of the jury. Now, there will not be cameras in the courtroom, I don't believe, for the jury, of course, for the voir dire of the jury. However, I do hope that there will be cameras in the courtroom if they go over some of these motions that I've been talking about. So I am going to go ahead and go live at 12:30 Central Time. That's accounting for Arizona time starting at 10 a.m. plus a 30-minute delay for any cameras in the courtroom. I may try to go live earlier than that if I find some information or if I have information that things are happening in the courtroom. I will go live sometime between 10 and 10:30 Arizona time tomorrow. That's between 12 and 12:30 Central Time. So I will make sure to report on anything that is happening with the motions. And yes, Yaha, this is another Daybell trial. Lori Daybell is on trial for conspiracy to commit or conspiracy to an attempted murder of Brandon Boudreaux, who was her former nephew, married to Melanie Boudreaux Pulowski. So Brandon is a surviving victim, and he's watching the trial proceedings via Zoom right now. And I don't know if he'll be in the courtroom tomorrow or not, but I will be streaming tomorrow starting around noon, somewhere between 12 and 12:30 Central Time, to cover any motions that they go over prior to having the in-person voir dire of the jury. Now, I'm probably not going to be live the entire time that voir dire is going on, because I don't want to be on a live stream for 4 hours just reading Twitter feeds. So what I will do instead is I'll cover anything that happens prior to the jurors coming in, and then I will do a recap when they recess for lunch, and we will see how things are going. So we will figure it out. And yes, Lori's defending herself again in this trial. She asked for Judge Beresky to be removed from the case, and that motion was denied this morning. And so justice for Brandon Boudreaux. We're all grateful that he is still alive. Thanks everyone for being here. Thanks for your support. Please make sure to like on your way out. That'll make sure that more of my content gets out to the people who are looking for it. I appreciate you being here as a family member, somebody who knew Lori before she was like this. It's important to me to be able to give a perspective on why Lori's. So I really appreciate you guys being here. And I appreciate your kindness, your good comments, your support, and I hope to see you again tomorrow. Take care.